Our guests today are Howard Dicker of Weil Gotshal. He's in New York City, and Vicki Westerhaus of Bryan. She's in Kansas City. We're going to talk about the legal proceedings section on Brock Romanek today on Zippy Point. So we are going to talk about the legal proceedings section, but first we got to talk about Howard's virtual background here. I'm going to put him in speaker view. And go ahead and say something, Howard, so they can see you.
I'm here, but I'm not really here. I am not in the Caribbean. It is not 85 degrees or something like that, but I can zoom in closer and we'll see. Let's see if you can see anything. No, I don't see anyone on any surfboarders out there. Do you? I don't see anyone surfing.
So that's an actual room partition. It's not a real virtual background. So Vicki and I are going to go and purchase our own room partitions after this Vid-Guide is over. But that's awesome, Howard. Thanks so much for making us feel warm inside. So when I was writing the treatises I've written, and I had to write the chapter on legal proceedings, that was the most challenging chapter I've written. It's a tough area. The case law in the area, there's not a whole lot of it. There's not a whole lot of case law about any of the SK items, let's face it, other than maybe the MD&A a little bit. But there's such great tension when you're drafting the legal proceeding section because you don't want to give away your strategy when you have an ongoing legal proceeding. And so there's always tension about making fulsome disclosure versus not giving away too much. And so the SEC has come in now and made some changes to item 103 of SK, first time in quite a while, if I remember correctly. And Vicki, why don't you start us off in going through those changes?
Sure, Brock. In 2020, the SEC adopted amendments to modernize legal proceeding disclosures. The SEC's stated purpose was to improve disclosures for investors and also simplify compliance for public companies. So to avoid duplication and help make SEC filings somewhat more reader-friendly, the SEC amended item 103 to expressly state that required disclosures may be provided by hyperlink or by cross-reference to legal proceedings disclosures in other parts of the document, such as in your MD&A, the risk factors, or notes to the financial statements. This amendment was driven in part by the item 103 and US GAAP disclosure requirements, which overlap to some extent. The SEC found that some companies were repeating some or all of the disclosure provided in their notes to the financial statements, while others were simply including a cross-reference to the note. So the second change to item 103 involved the materiality standard for disclosure of environmental proceedings where the government is a party. The SEC adopted a hybrid approach. So the amendments increased the quantitative threshold for disclosure of governmental environmental proceedings from 100,000 to 300,000, but also allowed flexibility for companies to select a different threshold that the company determines is reasonably designed to result in disclosure of material environmental proceedings. But so long as that threshold does not exceed the lesser of $1 million or 1% of the current assets of the company and its subsidiaries on a consolidated basis. The SEC explained that the increase from 100,000 to 300,000 was to adjust for inflation since the original disclosure requirement was added in 1982. And the two-pronged approach was intended to give companies flexibility to tailor their disclosures for only proceedings that are material to their business or financial conditions, subject, however, to the overall catch-all of the lesser of $1 million or 1% of the current assets of the company and its subsidiaries on a consolidated basis.
So as I understand it, November 9th was the effective date of this change. And there's only been a couple dozen companies that have made disclosures so far. And as you would expect, I think companies are going to take baby steps here. They're going to look to see what other companies are doing before they jump right in and make some radical changes. But what do you see as the pros and cons of selecting a higher threshold?
Well, before we go into that, actually, I thought, I was looking, reminded me of some of the rules here when we're talking about particularly the environmental laws. Environmental laws were very much on the SEC and just in society, in late 70s, early 80s. And so when the SEC adopted the $100,000 threshold in the early 80s, and I think that's the last time that amount was amended. That was the amount that was established, and now they've brought it the minimum, as Vicki's just said, the minimum threshold is the 300,000 for, and they use the CPI, Consumer Price Index, I think, to adjust it from those terms. I was just thinking about what it costs to, buy a Big Mac. I don't know if I think there's this Big Mac index out there from The Economist. And I was looking at that and comparing it to the CPI. And I think the Big Mac index, which actually hasn't been around since 1982, I think it was in 86 or something like that, has increased substantially more than that is the price of a Big Mac, has increased substantially more than the CPI index from 100 to 100,000 to 300,000. So in your tidbits of things, I think everyone should check out the Big Mac index or the cost of other things and see if maybe it should have been higher. I don't know. But Brock, and answer your question about the pros and cons, as Vicki stated, that there's now a more flexible hybrid approach on disclosure, where we have this dollar threshold for proceedings under environmental laws in which a governmental authority is a party and potentially involves monetary sanctions. So, we're focusing on this aspect of the threshold on government, involves governmental authorities on environmental laws and monetary sanctions. And as Vicki said, the threshold for disclosure is now 300,000, but the company at its option can choose a higher threshold that doesn't exceed the lesser of A, $1 million, or B, 1% of the company's current assets. With the caveat in the rule, though, that if the company chooses to use the optional thresholds, then the higher amount, then that higher amount must be determined by the company to be reasonably designed to result in disclosure of proceedings material to the company's business or financial condition. Meaning, when you pick that threshold, you have to bear in mind that it still must be able to detect or be required to disclose something that's material to the company. So first, I'll start off with the cons of selecting that higher threshold under the new rule. The first con, I think, is the company needs to actually disclose the dollar threshold used in each annual or quarterly report. When a company relies on the default threshold in the rule, no mention of 300,000 is necessary. And for me, I don't ordinarily see elsewhere in 10Ks and 10Qs, I don't ordinarily see a disclosure of a quantitative disclosure threshold being stated. So disclosing this amount might create or might give ammunition to plaintiff attorneys that chosen amount that you're now disclosing is a materiality level that should be used even in non-environmental related situations. Also, using the selection threshold creates its own analysis requirement, including to assess whether the threshold is appropriate. As I said before, you have to make sure that it is reasonable, and you need to explain changes to it. And finally, on the cons, the company will need to, 1, update its disclosure controls and procedures for utilizing this election. 2, appropriately document the calculation of the higher threshold. And 3, also document this assessment and determination that the higher amount is reasonably designed to result in disclosure of proceedings material to the company's business or financial condition. So the takeaway on the cons, I'm not sure how the SEC is going to handle like commenting in this area in the future, but this could be low-hanging fruit, a question that the staff may ask about, this justifying this higher amount, making sure it's reasonably designed to result in material disclosure. So now I'll work on the pros. Now the pros of using the higher threshold, after you do some math here, it seems to me that it's like a no-brainer for a company to select the higher threshold when the company's current assets are sustainably in excess of $100 million. So how do I get to the 100 million? You take the 1% of 100 million, and that's equal to the $1 million, which is the upper limit for non-disclosure under this optional threshold. And so, according to the SEC release, the SEC estimates that the $1 million upper limit represents about a 0.02% of the median current assets of a company in the S&P 500, meaning that the SEC expects that most large companies will be subject to the max. So, using this 1% thing, that's really not going to get you anything. They're going to be coming up against that $1 million maximum threshold, which is, substantially less than 1% of their current assets. In case you happen to be interested in some of the disclosures, there's been a few utilizing this election methodology. And just to give you a taste of it, I know that Home Depot and D.R. Horton made a recent, at least since the new rules, at least a recent disclosure. And so Home Depot's disclosure, for example, said SEC regulations require us to disclose certain information about proceedings arising under federal, state, and local environmental provisions if we reasonably believe that such proceedings may result in monetary sanctions above a stated threshold. Pursuant to the SEC regulations, the company uses a threshold of $1 million for purposes of determining whether the disclosure of any such proceeding is required. D.R. Horton's disclosure is that with respect to administrative or judicial proceedings involving the environment, we have determined that in the future, that in future filings, we will disclose any such proceedings if we reasonably believe such proceedings will result in monetary sanctions exclusive of interest and costs at or in excess of $1 million. We believe that such threshold is reasonably designed to result in disclosure of environmental proceedings that are material to our business or financial condition. So those are two recent examples.
Howard, what are your thoughts on whether plaintiffs' attorneys might challenge or question a company who sets its own threshold?
Well, I don't know if they're going to actually challenge that so much. I still think these numbers are sort of small for at least these kind of big companies. But I could see, even though it's completely different, I can see plaintiffs potentially seizing upon, even possibly the SEC, seizing upon any disclosure, and maybe not the SEC doing this, but plaintiff attorneys seizing upon any disclosure that that sets out a threshold and makes that decision. I can see it happening. I've seen all sorts of plaintiff lawyers making claims, and I don't mean to say plaintiff lawyers are bad, but I'm just saying that some of them will make, in my view, fairly spacious claims. And so if I was them, I'd be seizing on to any number I could.
I'd be surprised if CorpFin would question, second guess a company's threshold determinations, particularly if that comment will then ultimately gets publicly posted. But we'll see. It's been pretty rare in the past that CorpFin has commented on the legal proceedings section. Usually it's only comes up as an issue if the SEC Enforcement Division gets involved.
Yeah, Brock, I agree with that. The reason I wonder about them doing it, I just wondered if possibly, depending on what's on their plate, whether or not, like in some other types of disclosures, maybe they'll either review or do some observation of filings just to make sure that companies are putting companies' feet to the fire to make sure they're doing some sort of reasonableness analysis, rather than just saying, "Oh, my assets are higher, and here's the $1 million number." I'm not sure about that. Actually, I think maybe it's less likely to happen with the very, very large companies. There's this other set of companies, as I said, you do the math, for companies with more than $30 million in current assets, but less than $100 million. Now you're actually having those kind of companies having to decide whether it makes sense for them to just use that 300,000 now, a higher threshold that the rule says, or whether they're going to go through the effort of making the election such that they can not disclose a matter that's somewhere less than $1 million, less than whatever their 1% of current assets is, and the 300,000. Does it make sense? Is it worth it to them? And some companies may decide, well, it's always worth it never to disclose things, or kind of that mentality. Or they just may say, it's not worth it. 300,000, whatever. What does it matter? And another aspect of this, which we'll probably talk about later, is okay. We've been talking about 103, but there is something called the accounting, contingency footnotes, and those footnotes don't actually have specific thresholds like this. And for whatever, for various reasons, it's possible that something could be disclosable over there in the accounting footnotes, but not necessarily over here, even if you have one of these thresholds, depending upon the, the overall environmental matter that's involved.
Yeah, and before we dig deeper into that, Vicki, what about resetting a threshold? I know it's already too early to be thinking about when you're going to reset your threshold, but it's good to know that you can do that either upwards or downwards, I guess, based on how you see other companies or what they're disclosing, what becomes sort of the groupthink on this new world that we live in.
That's a great point, Brock. We have to keep in mind that materiality for SEC reporting purposes evolves and changes over time. So in essence, a company that chooses to select its own disclosure threshold will need to continually assess that threshold and think about whether it's still the right standard for materiality. And if the company decides that it needs to change that threshold, it'll have to explain any changes in the annual or quarterly report that applies at the time, as Howard said earlier.
And even when you set your threshold now, I would imagine, like some of those examples we were hearing Howard describe, you would have a little bit of cautionary language that, we might decide to change our threshold over time. And I don't know if that cautionary language is necessary, but it seems like it might be a good idea to keep people on notice that you have that option.
Yeah, I agree. I think it would be prudent to point out that materiality changes and evolves over time, and that the company may need to reset that threshold from time to time.
I think whenever people or whenever companies change things midstream, I think it's always subject to second guessing. I mean, the rule provides for this, and certainly if the company's current assets were to go up or go down, the threshold, if they were using the max on the current assets, meaning that they were one of those companies in the middle and not one of those companies in the max, in the large companies where they're up against the $1 million limit and substantially so they're really not going to be changing. But if they wind up in the middle, in the donut, they will wind up potentially needing to change, particularly if they've set a current asset number that's going to change every quarter. So that's probably not if you want to talk about cons, that's probably another thing that companies would want to avoid.
So Howard, do you think there might now be more tension between the company and their independent auditors because the companies have more discretion to have those disclosures perhaps get away from what's the contingencies disclosures look like in the financials?
Not really, Brock. I really think that the independent auditors are and the company's accountants are going to go focusing on their ASC 450 and SX requirements under and GAAP requirements for the financial statement footnotes, and focus on those in addition to any other guidance that the SEC has, like the staff accounting bulletins and other items for the financial statement footnotes. And when we come to this, I think that despite the fact that people will be, we have now under the rules specific authorization to cross-reference from the financial statements or hyperlink into the 103 disclosure, I really don't think the role of the auditor is going to change here. I find that certainly in the 10K, of course, or in a registration statement that requires 103 specifically, the auditors certainly will be reviewing the disclosures outside the financial statements. But I think the focus will be, for them at least, on the financial statements and the notes. And when it comes to this item, companies will need to be responsive to the 103, and to the extent they can not be repetitive and effectively incorporate disclosure from financial statement footnotes, they will. Obviously, when we've been talking about these thresholds and the like, we're talking about really just a subset of the types of disclosures that find their way into 103. We're talking about, in particular with this hybrid threshold aspect, we're talking about proceedings by a governmental authority, and having, and it can be broader than that, but we're talking about criminal, not necessarily criminal, but penalties and sanctions and fines from environmental bodies.
But I think we'll still see a fair amount of just simple cross-referencing being repetitive and not a whole lot of innovation, at least at first, as companies wait to see what others are doing, which sort of a self-fulfilling prophecy. If everyone keeps doing the same thing, then nothing's ever going to change. So Vicki, what about environmental proceedings disclosure as it relates to this growth of sustainability and ESS reports that are issued outside the SEC filing stream? How might some of that disclosure from those other reports creep into the 103 disclosures?
Well, we've got a lot of companies now voluntarily publishing ESG information or reports on their websites, as you mentioned, Brock, and that's really outside the SEC reportable framework. So a lot of times these companies are including information, environmental information, that's not material for SEC reporting purposes, but that investors and others want to see. So companies will really need to be mindful that materiality, as I mentioned earlier, for SEC reporting purposes can evolve and change over time. And think carefully about what they're putting on their website and whether the SEC or others, investors or plaintiffs' attorneys, might take a view that what you're putting on your website really should be material for SEC reporting purposes as well. And there, as Howard mentioned, they'll have to look carefully at disclosure controls and procedures, not just for what's in the SEC reporting documents, but also what's on the website, because they could be held accountable for that as well.
Vicki, I totally agree with that. I think that companies, just as a broader, whether it's environmental, just when we see companies with whether it's ESG reporting, diversity and inclusion reporting, lots of stuff that companies are either publishing books or just on their website. Sometimes unfortunately I've seen I just wonder, how are they saying that? I just look at that and I say, wow, what are they doing? And I say to myself, and so whenever I'm with clients trying and I'm being engaged to deal with things, I'm saying, really scrub that. I know it's partially marketing materials, or there's a slant towards there, and the company pays people to do that, and they just need to make sure they're looking carefully, and all those superlatives or commitments that are being made in some other documents, that appropriate people at the company are looking at those from not only disclosure controls and procedures point of view, but a risk assessment of what they're saying, because I don't want the companies to get out of over their skis, as some might say, of what they either can deliver or accuracy for that matter. So I think that's really important overall, and I don't typically, for part of that reason, when it comes to like environmental penalties from the EPA or other governmental authorities regarding environmental matters, I don't typically see in environmental or, sustainability or whatever reports, someone saying, the EPA made us go clean up some dump somewhere. I don't, it's not something that the companies are typically looking to say. They're usually talking about, here's what we want to achieve and here's how we're progressing towards achieving those goals, rather than, someone hit us with a vine. So that's my views of at least what I'm seeing.
That's very true. I totally agree, Howard. A lot of times the ESG reports do read more like marketing materials and definitely haven't been vetted in some cases by securities lawyers. So people really need to think carefully about the statements made in there and have appropriate backup for the statements made in there, and have a way to track so they can show progress. If it's more of a, hey, here's all the great things we're doing to help the environment, they really need to have backup, strong backup for those statements.
Right, and I know by just I think a Googling, and certainly some of the accounting firms are in this as well, but there's other third-party advisors out there that are more than willing to help companies check on their and say either perform some sort of review of their ESG reporting to ensure that there is some level of accuracy, accountability, it ties to something, the support, all that kind of stuff. And that's something that companies need to think about as well.
Yeah, particularly the commitments, any forward-looking information like that, you got to be really careful. Even if they're outside the SEC reporting stream, you still might get sued in a securities lawsuit. So thank you very much for your time and expertise. And I do feel warmer already, Howard.
Okay, great.
Thank you.
Thank you, Brock. Thank you, Howard.
Thanks.
We are going to talk about the legal